Welcome to Juris Stupidity, a video podcast highlighting the incorrect use of legal terms and concepts by politicos and talking heads. Talking heads who mangle simple legal matters and otherwise mess up discussion of legal issues. The aim of this podcast is to alert you to when the utterances of misguided commentators are just plainly wrong and maybe even misleading. It will also alert you to when those jokers haven't a clue on what they're talking about. Also, you don't have to take what I say on faith. In this podcast, I use only well-established black-letter matters. At the end of every podcast, I provide my sources of information so that you can easily check my accuracy. The subject of this episode is constitutionality. The legal concept is bantered about frequently, but rarely used properly by the talking head class. Indeed, it is possible that the term constitutional is the most abused legal term in social and regular media. In the United States, the law on whether a statute or executive order is unconstitutional under the United States Constitution has been well established for a very long time, since 1803. That case is Marbury versus Madison, and the law in this old case is alive and well today. This case stands for the proposition that the United States Supreme Court has the exclusive, quote, province and duty, quote, to say what the law is with respect to whether a law is contrary to the United States Constitution. To see that Marbury versus Madison remains good law in modern times, you need only look to the 1974 case in which the United States Supreme Court held that President Nixon could not use executive privilege to withhold evidence in a criminal trial, saying that the court had the power to make such a determination. In this case, the court said, quote, many decisions of this court, however, have unequivocally reaffirmed the holding of Marbury versus Madison that, quote, it is emphatically the province and duty of the judicial department to say what the law is, end of quote. The test whether a law can be said to be constitutional is simple. It is whether a federal court, or more importantly, the United Supreme Court, has determined whether a law or order is unconstitutional. If a court has, then it is unconstitutional. If not, the federal law or executive order is presumed to be constitutional. So when some politico or talking head blathers that a new law is unconstitutional, you know instantly that the speaker has its head or mouth somewhere where the moon doesn't shine. It is equally well established that a federal statute or executive order is deemed to be constitutional unless and until a federal court, or more importantly, the Supreme Court, strikes it down. While it is possible for persons to hold views on the likely constitutionality of a particular law, it does not mean it is so. The bedrock test is whether the federal courts, particularly the United States Supreme Court, have made a determination. Lacking such a determination, a talking head's smug pronouncement of constitutional status is simply air making noise out of a throat. That's proper use of terms of constitutionality. See if the next talking head you watch gets it right. Probably not.